impossible things possible. So let us begin this session by seeking the blessing of the Lord Almighty with a prayer song.
I love you, Lord. Oh, your mercy never fails me. And all my days I've been held in your hand. From the moment that I wake up until I lay my head, oh, I will sing of the goodness of God. Of God, I love your voice. You will lead me through the fire, and in darkest night, you were close like no other. I've known you as a father, I've known you as a friend, and I have lived in the goodness of God. Yeah.
Now I take this opportunity to welcome and introduce the chairperson for this session. Dr. B. Thiba is a registered Indian patent attorney and hold a doctoral degree in analytical chemistry and bachelor's in law. She obtained the Women Scientist Scholarship Award specializing in intellectual property right instituted by the Department of Science and Technology, Government of India. She has several years of experience in the field of IPR. Presently, she is running an IP firm, Bhavesh Associate, an entity of Intelpat Patent Solution in Chennai. Dr. Thiba has profound potential in diverse technical field for patent, including physical sciences, life sciences, biotechnology, pharma, medical, and the like. Mr. Thiba offers services to R&D labs, industries, and academic institutions, and provide assistance right from drafting the application and filing the prosecuting till grant. I am very happy to have such an eminent person in our midst today. I welcome you, ma'am. I also welcome our secretary, Reverend Sister Flora Mary, our principal, Dr. Reverend Sister ASJ Lucia Rose, our deputy vice principal, Dr. Reverend Sister Kulandi Teras, our HOD, Dr. Glory, overall Star College Scheme Coordinator and Member Secretary, Dr. Reverend Sister Arokya Genesius Alphonse, HOD of various learned professors from various other institutions and from our institution. Once again, I welcome you all for this wonderful session. Dear participants, kindly switch on your cameras and join us for the group photo session.
Thank you, dear participants.
I request Dr. Thiba, Registered Patent Agent, Chennai, to take over the session. Is the screen visible, ma'am?
Yes, ma'am, visible.
Okay. Thank you, ma'am, for the nice introduction. And also, I extend my heartfelt thanks to the organizing committee for inviting me to deliver the lecture on the said topic. The topic goes like this: Introduction to Patent System and Filing Procedures. So it's just an introduction of what is a patent and what are the patentable subject matters and how we have to file a patent application. Okay. What is a patent? People used to think patent is a scientific invention. The answer is no. Patent is not a scientific invention. It is a protection. It is a right. Patent is a right granted by a national government for an invention. So it is a right given to a person who has invented the invention by the national government. So patent is a right. So since it is granted by the national government, you have to file in each country individually. That is, if you want a right in India, you have to file patent application in India. If you want that right in US, individually, separately, you have to file your patent application in US. So that's what. In each country, we have to file individually. I said it is a right. So what right you are getting here is, this protection exclude others from making, using, or selling an invention for a period up to 20 years. So this is the right you are getting. So you can prevent others if you have a patent right with you. Okay, what is the right you are getting here is, you can prevent others to market, manufacture, and use the invention. So this is a right you are getting. And then, I must say, not all scientific inventions can be get patent right for that. Only those inventions which is new, useful, and not obvious, only will get the patent right. Okay, so for an invention to become a patentable subject matter, it has to be new, useful, and not obvious. I will explain what is these things in the forthcoming slides. Okay. Excuse me. In India, it is enshrined in Patent Act 1970 and it is operative whole of India. So the objects, everything is given in Patent Act 1970 and it is operative in whole of India. So what is this object of this patent law is? To enjoy the exclusive right over the invention. So you can enjoy the right, and to encourage scientific research, new technology, and industrial progress. See, it is not just like that. You cannot do an invention. It involves time, energy, money, everything to come out to arrive at an invention. So government wants to give some encouragement to the scientific research, new technology. So they have given a right over your invention, and of course to ensure commercial returns for your invention. And this was taken from a famous Supreme Court judgment, where the judgment states the object of patent law, the price of grant of monopoly is the disclosure of the invention at the patent office, which after the expiry of fixed period of monopoly passes into the public domain. So this is the object. That means, see, government is giving right to you for a particular period, and after that it should be open to public. Anybody can market, manufacture, and use your invention. So this is the very ultimate object of this patent law. Okay. And then a crisp definition of what is a patent. It is a monopoly right. I said it is a right granted for an invention. So what is the right for? Invention, and it is granted by the government to the inventor or his assignees. That is, it can be, the right can be given to the inventor, or if you are working or you are studying in a college or in an organization, the organization will become the owner of the patent. And it is for a period of 20 years and it is valid within the country of grant. So this is the definition of a patent. So it is a right for the invention by the government to the inventor or his assignees, for it is only for a period of 20 years and it is valid within the country of grant. So I said it is a monopoly right. What right you are getting is, I must say it is a negative right.
So exclusivity of right implies no one else can make, use, manufacture, or market the invention without the consent of the patent holder. So this is the right you are getting. So you can prevent others to use your patented product. Next, I must say, 3 statutory pillars. I said initially, not all scientific inventions falls under patentable subject matter. So the 3 statutory pillars for an invention to become a patentable subject matter, it should obey these 3 conditions. That is novelty, inventive step, and industrial application. These are the 3 essential conditions. It should be new, it should be not obvious, and it should be useful. So we will see one by one. What is new? What is novelty? Which means your invention, your scientific invention should not form a part of global state of art. So what is global state of art? Information appearing in magazines, technical journals, books, newspapers. So your invention should not be available elsewhere in the global state of art. And you are describing your invention in a oral or a seminar, conferences, oral description, workshops, it will lose novelty. And you are not supposed to use your invention also before filing a patent application. And then novelty is assessed in globalized context. That is, your invention may be new to India, but you cannot get a patent right if it is already available in US. Okay, so novelty, it is assessed in globalized context. So this is the first criteria for a patent, for a scientific invention to become a patentable subject matter. That is, your invention should be new. The second one is not obvious. Inventive step. Your invention should have inventive step. That is, inventive step means a feature that makes the invention not obvious to the person skilled in the art. That is, your invention should be inventive, which means it should be either a technical advantage of the existing thing or an economic significance. If it is cost effective, such kind of inventions are patentable. Usefulness. An invention must possess utility for a grant of patent. No valid patent can be granted for an invention devoid of utility. That is, if you have an invention, definitely it will be having some use, So if there is no use, no patent shall be granted. So these are the 3 essential conditions for an invention to become a patentable subject matter. That is novelty, inventive step, and it should be used. So these are the, so please keep in mind, these are the 3 conditions for an invention to become a patentable subject matter. It is novelty, useful, inventive step. Okay. Next, even though your invention is, these are the very certain definitions in the Indian Patent Act. What Patent Act defines is invention is a new product or a process involving an inventive step and capable of industrial application. So this is what Act defines. Invention is a new product. It has to be new. Okay. It can be a product or a process involving an inventive step. That is technical advantage. Your invention should have technical advantage or economic significance, cost effective, and capable of industrial application. That is, your invention is useful. So this is what Act defines. What is inventive step implies technical advantage or economic significance or both. So this is what inventive step is. Capable of industrial application means invention is capable of being made or used in the industry. So which means it has to be either a raw material to an industry or an end product of an industry. So I just want to share these definitions in Indian Patent Act. So invention, it has to be a product or a process, and it involves 3 steps, 3 things: new, useful, inventive. And see, even though your invention is having all the 3 criteria, so the 3 criteria is new, useful, and inventive. If it falls under Section 3 and Section 4 of Indian Patent Act, no patent shall be granted. So then what is Section 3? Section 3 states what are not inventions. So Section 3A states frivolous or obviously contrary to the well-established natural laws. That is, if somebody comes out with a time machine so that you can go to the past or the future, such kind of inventions which are against natural laws, so no patent shall be granted. excuse me. Section 3B states, contrary to public order or morality, prejudice to human, animal, or plant life or health or to the environment. That is, if your invention, you have invented something, a device or a method for committing theft or a biological warfare weapon, such kind of inventions will against public order or morality. So no inventions, no patent shall be granted. Mere discovery of scientific principles, abstracts theories, living things or non-living things. So discoveries are non-patentable. Only inventions are patentable subject matter. And then new form, new property, new use of a known compound is also non-patentable. So you take this famous example, aspirin. Aspirin, as we all know, it is an analgesic property. Later, it was found to have a cardiovascular property, that is a blood thinning agent. And they have filed a patent right for aspirin as a blood thinning agent. So patent office rejected the patent, stating that it is aspirin is already known in the state of art. New use, actually it is a new use. Aspirin's analgesic property is already known. What I have found is blood thinning property. So new use of a known compound is not falls under patentable subject matter. And mere admixtures, you are mixing A, B, and C, and it leads to only additive effect, no patent shall be granted. If it exhibits synergism, then we can have a patent application for that. But if it is an additive admixtures, no patent shall be granted. Mere arrangement, rearrangement, and duplication of known devices, no patent shall be granted. That is just like umbrella cum torch, which is innovative thing, but umbrella is already known, torch is already known. So arranging and rearranging of known devices is not patentable. Method of agriculture or horticulture is non-patentable subject matter. And method of treatment is non-patentable in India. So if a particular person is invented, see why it is not patented in India. The reason being, India being the developing country. See, in US and all, method of treatment claims are allowed in the US. But in India being the developing country, what happens? What happens like if a method of treatment claim is allowed? So that particular surgeon will have patent right over the treatment. So whatever cost he is fixing, we have to pay. See, what right he is getting? He can prevent others to do the surgery because he has got a patent right. Which means whatever fees he is fixing, we have to pay because he has got patent rights over that method of treatment. So in India being the developing country, such claims are not allowed under Section 3I of Indian Patent Act. How a patent can be obtained for surgical, therapeutic, diagnostic instruments or apparatus? For these things, we can get patent right. That is surgical instruments like surgical knives or some dental instruments, such kind of things we can get a patent right, but not for method of treatment. Plants, animals, including seed varieties, species, biological process, these are all falls under Protection of Plant Variety and Farmer Right Act, are not under patent right. Method of business methods, computer program per se, algorithms, literary, dramatic, musical or artistic work or other aesthetic works, scheme, rule, method of performing mental act, playing games, presentation of information, topography of integrated circuits, and traditional knowledge. So these are all non-patentable under Section 3 of Indian Patent Act. That is, so there is no patent right for neem, turmeric, basmati rice, etc. So this what Section 3 states. Even though your invention is new, useful, and inventive, if it is a method of treatment, no patent shall be granted. If it is a traditional knowledge, no patent. If it is an arrangement and rearrangement, no patent shall be granted. Section 4 also states inventions non-patentable. Section 4 states that no patent shall be granted in respect of invention relating to atomic energy falling within subsection 1 of Section 20 of Atomic Energy Act. So what this subsection 1 of Section 20? If I am using a radioactive substance like uranium, thorium, plutonium, or gamma radiation, and if it is harmful to the environment or the society, no patent shall be granted for the inventions. Okay, so that's all about patentable subject matter, patenting system in India. So you have a patented invention with you. Okay, if you have a patented, scientific invention with you, first three things what you have to check here is novelty, usefulness, industry, inventive step. So these are the three conditions. Even though your invention is having all the three, you have to check whether your invention falls under section 3 and section 4 of Indian Patent Act. So if your invention is a method of treatment, or if your invention is having a uranium or thorium where it affects the environment, no patent shall be granted. Okay, so you have got a patent invention and falls under patentable subject matter. The next one is patent filing procedures. So how to file a patent application? Okay, when to file a patent application? This is very important. Earliest possible date. You have got a scientific invention with you. So immediately go and file your application in the patent office. Why? Because delay in filing an application may entail some risk, like other inventors may apply for the patent for the said invention. That is, see, for example, if you are in a outburst of dengue fever, so everybody will be doing research for finding the medicine for dengue. And believe me, everybody will work in the herbal papaya. Papaya is very known for treating dengue fever. So everybody will be working in the thing. So whoever files the first will get the patent right. So that is the reason why earliest possible date. Once you got a positive results in your study, just go and file your application in the patent office. Otherwise, other inventors working in the same field will file the application, or you yourself will inadvertently publish your invention in some journals or present in some conferences, etc. So what happens if you publish your invention? The novelty is lost and you won't get a patent right over your invention. Your own invention, if you publish it before filing a patent application, you will lose the patent rights. So this is a very important question as far as academicians are concerned. Can a published or disclosed invention be patented? So I have a scientific invention. I have published that invention in a high impact journal. So can I file a patent right over that? The answer is no. Publication of an invention in any form before filing the patent application, which disqualify the invention to be patentable, you will lose the novelty. So just keep in mind that you are not supposed to publish your invention. Only thing is you have to file the patent application, and then after filing the patent application, immediately also you can publish or you can commercialize, you can exploit your invention. That is a different thing. Only thing is first you have to file our application. So in the patent filing procedures, we have to draft the application. So drafting is very important as far as patent application is concerned, because see, the right you are getting is only for 20 years. After 20 years, it is open to public, and any skilled person skilled in the art will go through the document. He should be able to reproduce their invention. Then only it will be available in the public and anybody can market, manufacture and use. So this is very important. If you are not drafting the invention properly, that is also a valid ground for rejection of the patent application. So you have to keep this in mind. So there are two types of patent documents, usually known as patent specifications, namely provisional specification and complete specification. These are the two patent documents. So these are the various contents of a specification, which is similar to that of journal writing, where you have to write the title of the invention, field of the invention, background, object, summary. If it involves any drawings, you have to mention the drawings and you have to describe the drawings, and detailed description, examples, claims, abstract. So these are the various contents, that is captions of a specification. And if you are filing only provisional, claims and abstract is not necessary. I said provisional. Provisional, there are two types of documents. One is provisional specification and another one is complete specification. Coming to provisional specification here, if you have only a pilot studies and you are very confident that it will come out with fruitful results, then in order to establish the early priority date, we can go and deposit our application in the patent office. So what this provisional specification contains, it should describe the nature of the invention and contain the description of essential features. That is, just essential features of the invention is sufficient for drafting the provisional specification. And then claims and abstract is not the part. No need to give claims and abstract. Fees is same. And then complete specification must be filed within 12 months from the date of filing the provisional application. So, which means within 12 months, we have to file the complete specification. So it will be a sort of driving force for the researchers. Once we file a provisional, within 12 months, you have to complete the result and submit the application the patent offers. In contrast with provisional, complete specification contains full description of the invention and its operation. See, provisional, just essential features is sufficient. Complete, you have to give full description of the invention and its operation and the best method of making the invention. That is very important. So why? Because after 20 years, it is open to public. Any people can reproduce your invention. And it should end with claims. Claims is the techno-legal part of the complete specification for which you are sorting the protection. And it is accompanied by an abstract. That is, it just abstract, brief, one para. It should have 150 words. Okay, you have to describe your invention. And then, if the invention is involving biological materials, for example, like a plant or an animal extracts or microorganisms, such kind of things, we have to deposit our biological material in International Depositing Authority. In India, it is in IMTech Chandigarh. Okay. So first thing is you have to deposit the biological species in IMTech Chandigarh. Excuse me. And also we have to get approval from National Biodiversity Authority. If you use a plant or animal biological material, you have to get approval from Biodiversity Authority to claiming monopoly right over your invention. Okay. So that's all about drafting of a complete specification. That is, you have an invention with you. The first three things is novelty, inventive step, and industrial application. And then it should not fall under Section 3 and Section 4 of Indian Patent Act. And then the next thing is you are not supposed to publish your invention. You have to draft it. It should be completely, you have to disclose your invention. That is a style of drafting the Indian patent application that various contents we have seen already. So you have drafted. And then the three important questions is, who can file a patent application, where to file, and how to file a patent application? Who can file? The inventor, the true and the first inventor, the person who is, it is an intellectual property right. So the property arising out of human intellect. So a person only, a human being only would have invented the thing. So who has the right? The inventor has the right to file the patent application. Or if a college or an organization is giving financial support and infrastructure, everything for doing an invention, then the assignee, they'll become assignee. So the assignee has the right to file the patent application. Okay. Or legal representative disease, that is, it is a property, intellectual property. So if the inventor is no more, then his legal representative has the right to file the patent application. So these are the three persons who has the right to file the patent application. It can be an inventor or an institution or the legal representative of the institution or the deceased person. Where to file? So you have drafted and you want to file. Where to file the patent application? In India, there are 4 places. We have patent office: Chennai, Mumbai, Delhi, Kolkata, where we fall under Chennai zone, where Kerala, Karnataka, Tamil Nadu, Andhra Pradesh, Telangana, Puducherry, we all belongs to Chennai jurisdiction. So our patent office lies in Chennai. It is in Gindi, in Chennai. So we have to file only in Chennai patent office. How to file a patent office? So you have selected in which patent office you have to file. How to file? It can be filed through online, or it can be filed through post by sending the speed post. And registered and speed post, Indian post only have to submit, not by couriers. and it can be directly go and submit your application by hand. The thing here is now, because we are in amidst pandemic, nobody is allowed inside the patent office except the staffs who are working in the patent office. So everything has become online now. And this is the procedure for filing a patent application. So yes, so is the flow chart. So first thing is you have to do a search, prior art search. So in that prior art search, what you will find is whether it is having novelty, inventive step, and industrial application. And if it is not fall under section 3 and section 4 of Patent Act, you can go and file your application in the patent office. You have to draft the patent application and file it in the patent office. After filing, it will get published in the patent office journal. So it is called automatic publication, where it will get automatically published after 18 months. Whatever you are submitting, it will get published after 18 months from the date of filing. Or alternatively, you can opt for express publication by paying excess fees, so that the publication will happen within 2 weeks time period. Okay, so for this, no need to pay any fees. It will get automatically published. So that is what it is called, 18 months publication or automatic publication. Or you can opt for express route, so that publication will happen within 2 weeks. And then 48 months from the date of filing the patent application, you have to file request for examination. Anytime you can file at the time of filing itself or within 48 months. Okay. And then after filing the request for examination, we will be receiving examination report. That is the first examination report, where patent office will issue a report stating that our invention is similar to various documents, and we have to defend, we have to reply to that examination report stating that our invention is different from the cited documents. Okay. After defending, if the controller is satisfied with our reply, they will grant the patent. Else, they will call for hearing, and then grant or rejection will take place. And then decision of controller will be the final. So this is the procedure for patent filing. That is, initially you have to file the application, and then publication, and then examination, and then reply. You have to file the reply, and then the grant or refusal will take place. Okay. So these are the documents that is required for filing a patent application. That is, you should be having a covering letter, and then form 1, that is application for the grant of patent, and then form 2, which is the technical part, where you have to, we have seen no complete specification and provisional specification. Those things which we have to submit in form 2. And then form 3, that is like if you want to file patent application outside India, you have to give a statement and undertaking in form 3, that is comes under section 8 and rule 12 of Indian Patent Act, where we have to inform the patent office regarding whether you have filed your international application or foreign application. And then form 26, if it is filed through an attorney, so we have to have the power, right? So form 26 is giving power by the applicant to the attorney. And declaration of the inventorship, that is who are all the inventors. And then if you are filing from outside India to entering into India, you have to submit the priority document, and of course with the fees. So these are the various forms and documents which are required for filing the patent application in India. So far we have seen what are the various filing procedures for filing the patent application in India. So first we have to file the application, and then publication, and then examination, and then finally we will get the grant. Coming to international applications, there are 2 routes. Okay, there is nothing called international patent. So I have got a patent, right? So it can be automatically protected throughout the world. No. If you want to file, get protection in all the countries, you have to file each countries individually, and each countries will be having their own patent laws. Okay, so in India we don't have method of treatment claim. In US they will be having. So while submitting your application in US, you have to draft accordingly, according to their law. Okay, so just take into consideration, there is no international patent. In each country you have to file individually. So the two types in which you can enter into international phase, that is, you want to file in each country individual, there are two routes. One is conventional application, another one is PCT. What is conventional application? See, like first, say being an Indian citizen, we have to file first only in India. And then within 12 months, you want to enter into whatever country you want. Okay. So this is what conventional route, which is first we have to file our application in India, and within 12 months, you have to, if you want to file in US, UK, Japan, China, Russia, so whatever countries you want, within 12 months you have to enter. So this will be the priority application. So this is what conventional route, that is within 12 months you have to enter into all the countries. In PCT route, that is patent cooperative treaty, first we have to file our application in India, and then you have 30 months and 31 months time period to enter into whatever countries you want. Okay. So what will happen during this period? First, you have to file our application in India, and you have to file an application in PCT. We have to deposit our application in Patent Cooperative Treaty, WIPO, World Intellectual Property Organization. So it is just a sort of depositing our application so that we are designating all the countries. Okay, we are designating all the countries. It is not filing in all countries. We are just designating all the countries that we are going to enter into whatever countries we want. So that is time period is within 12 months. India being the receiving office, we can deposit our application in India itself, or you can deposit through online to directly to WIPO also. And then we will be getting the search report, publication, examination report, everything. So you will have an idea. See, once we receive a search report, we will get whether we will have an idea like whether our invention will get granted or like that, whether our invention will be granted or not. Then you can spend your money in filing in all the countries, that is 31 months. See, for filing a patent application in US, it will cost around 7 to 10 lakh Indian rupees. So here in conventional route, within 12 months, you have to spend that money. In PCT route, we have time till 30 years. Meanwhile, you can get an investor for investment, or you can get an idea that definitely it will get granted by receiving the search report and examination report. So we can opt accordingly. So in filing of international application, India being the receiving office, we can file in India, or directly you can file in International Bureau, that is Geneva, through online. So these are the documents which are required for filing the international application, that is to PCT. Should have a covering letter, and PCT request, it is just a formal form which involves who are the applicant, who is the inventor, the name, nationality, address, everything. And then the complete specification, everything, it should be in 3 copies, triplicate, complete specification, abstract, drawings, and fees. And what are the fees under PCT is, you have to file a transmittal fee for transmitting from India to WIPO, and a priority document fee, international filing fee, and search fees. So these are the 4 fees we have to file under PCT. Okay, who is a patent agent? See, patent office themselves will recommend that if you have an invention, you file through a patent agent, because we are patent agent. Who is a patent agent? Is an individual who has qualified Indian patent examination. Okay, the eligible criteria, the eligibility to become a patent agent is he or she should be an Indian citizen and 21 years of age. And then he has to have a master, bachelor's or master's in science and engineering from any recognized university. But what I feel is, if you want to become a patent agent, you have to have at least a master's degree, so that it will be easy for you to judge a research and draft an application and prosecute the patent application in the patent office. So what are the information you need to be consulted the patent attorney here is, as an inventor, you have to completely disclose your invention. So what kind of disclosure? Everything right from the beginning, how you have arrived at an idea. See, invention won't arise just like that. You might have seen some inventions. You feel that there are some disadvantages over the inventions for which you have found an advantage. So all the things completely, you have to disclose your invention to a patent attorney like me, so that it will be easy for us to draft, because you know better than us. You are the inventors. I can directly submit, disclose the inventions to patent attorney. So it will be easy for us to draft the application and file the application in the patent office to get the things done. Thank you. Any questions?
Madam, I have very few queries.
Yes, sir.
This is Dr. Muthukumar.
Okay.
Regarding that, like yearly publication rules.
Okay.
Is there any norms are there, like myself and is it compulsory for male as well as like female people must be there in the yearly publication rules?
Excuse me. For publication, for female publication, there is no rule that it will be, I mean, for yearly publication, there is no rule that we have to, like, female must be there. For express examination only, the female applicant, if there is female applicant, Government of India has given some privilege to the female people where we can opt for early examination so that the grant of the application will happen within 1 year. Any other questions, sir?
Yes, ma'am. I thought the question is over. I don't know whether. Shall I ask the next question, ma'am? Ma'am, regarding the filing and the publication, I have. I need some clarification on when we will call that the patent is published, and when we can call it as the application is still in process. Because I have filed for 8 patents. Now it's still there in the application stage. When I will be, getting that publication grant. What is the difference between that publication and publication grant?
No, actually, see, before the previous amendment, there was called publication of grant. Okay, the grant will get published, and later only the grant we will be receiving the grant certificate. So that is different. But present case scenario is, once we file the application, if you opt for express publication, it will get published. Now we can say that the patent application published. So if it is published in the patent office journal, the status will be published. If it is granted, means you have to receive the first examination report, and then we have to file the reply, and then the hearing will happen, and then the final grant certificate, we will receive the grant certificate. So patent application published means 18 months publication. That is publication without any prosecution. Our invention, what we have submitted, it will get published in the journal. That is publication. And then that is publication of application. That one is grant. Nowadays, they are not using the terminology publication of grant, just grant. We have received the grant certificate. So publication and grant.
I'm still not able to get it. The publication, if it is published in journal, whether we can assume that the patent is published?
Patent application is published.
Okay.
It is not patent application is published.
Okay.
Another is patent is granted. The last stage is it is no longer application. It is final patent document.
Okay.
Initially, it is application. Final is patent. Patent granted. Okay. Patent application published. Patent granted.
Okay. So I need to wait till patent is granted. Okay. Okay. Fine. Yeah.
Maybe we can say like patent application published. Patent published.
Okay. Yeah. Thank you.
Okay. Any other questions? You can type in chat box also.
Like in joint applicants, like the institute level as well as the individual person. individual. Okay, my is it's a
Your voice is breaking, sir. Your voice is breaking.
I'll
What is your question, sir? If the applicant contains both the individual and the college, who will get the right?
yes.
Huh?
Yes. Who is get the whether that is possible or not?
Who will get the right? Right? See, if it is a joint applicant, that is both college and individual, both are in the applicant side, both will get equal rights. So it is a property, it is an intellectual property, both will get equal rights. And then one question from the chat. If we can do a patent for the formula of an innovated food product. Okay. So what are the requirements? If you have invented a formulation of a excuse me, of a food formulation of a supplement or something like that, what we need is you are giving a combination of ingredients. No, that combination should be novel. The novel combination you have to give, and then you have to prove synergism, because each food thing will have some property. You have to give that because of my combination, I am getting the enhanced efficacy. So such details you need to give. If the formula is novel and you are able to prove synergism, then we can file a patent application for innovative food products also. What should be the joint application with individual and institute is possible? What should be the fees? Okay, so previously there was fees different, but now for joint application for individual and the institute, the fee is one and the same, provided the institute is an educational institution. The fees is the same. If we file only individual, also same fees, only institute same fees, together also same fees only.
Ma'am, one more question. This is Dr. Kishore. Ma'am, as we are talking about fees, is there a fee difference when it comes to the domain? Like, for example, mechanical engineering and commerce management. Is there any fees difference?
No, sir. As far as government fees is concerned, it is same only. For attorney also, they will be fixing some rate, no, for drafting one application. And I myself won't, I never come across if it is mechanical, it will be more, not like that. All inventions, they will be having one tariff. Attorneys will be having one tariff. For one patent application, they will charge this thing. There is no, discrimination between the domains. For all the domains, you will be having the same fee only. Both government and attorney fees.
Following that, how many can join together for one patent?
There is no limit, sir. There is no limit. N number of people can be an applicant or can be an inventor.
Thank you.
And then another question, will patent document will stored in images or data in patent server? It will be in images only, sir. But nowadays we are submitting through online. We are converting the Word into the PDF now. So you can easily convert that PDF into Word also. So if it is physical filing, they will scan our page and it will be stored as image. If it is online filing, it will be in data only. We can it will be in PDF. Anybody can convert into data.
Okay, ma'am. Thank you, ma'am. Thank you so much.
Thank you. Yes, ma'am.
If no question further, shall we go ahead with the formal vote of thanks? Hello, Sumati.
Yes, ma'am.
Shall we go ahead with the formal vote of thanks if
Okay, ma'am.
participants?
Gratitude opens the door to the path, the wisdom, the creativity of the universe. I am really thankful for giving me a chance to deliver a vote of thanks for the second day of the faculty development program on intellectual property rights. First of all, I thank God Almighty for this blessing and grace to complete today's program successfully. I would like to thank our resource person, Dr. Tiba, Registered Patent Agent, Chennai, for making the excellent presentation and making today's session interesting and meaningful. We are really enlightened with your knowledge on the topic Introduction to Patent System and Filing Procedure. Thank you so much, ma'am, for accepting our invitation and sharing your knowledge with us even in your busy schedule. I am sure that the ideas that you have shared with us will definitely help us for our future. I also express my heartfelt thanks to our Secretary, Reverend Sister Flora Mary, Principal, Reverend Dr. Sister A.S.A. Lucia Rose, Deputy Principal, Reverend Sister Kulandai Taras, Dr. M. Glory, Head and Associate Professor of Botany, and the overall Star College Coordinator and Member Secretary, Reverend Dr. Sister Aroki Genesius Alphonse, for providing us this interesting opportunity to learn new things. My heartfelt thanks to participants from various other institutions and from our institution for their active participation. Once again, I thank you to all.
Thank you, ma'am.
Thank you, Dr. Sumadi, for extending the vote of thanks. Madam Deepa, Madam, I am Dr. Glory, Head of Department of Botany. Sorry, I was late to join. The session was highly interesting and highly informative. That discussion session also very fruitful. Thank you so much for all your effort.
If you have any doubt, or if you want to prosecute your patent application, you can contact me, ma'am.
Sure, ma'am. Sure, ma'am.
All the members.
Thank you so much for your strong expertise in the field of IPR, ma'am. Thank you so much once again.
Thank you.
Okay.
Feedback link is posted on the chat box. Kindly fill the form. Dear participants, we shall meet tomorrow at 4:15 p.m.